From the supplementary list, under heading for admission, item 2, DA.25.03.2026 of 2026.
From the list.
Yes, CS77.
What is it?
That is the labor matter may not be the 2005 may not be whatever made in favor of my plan B employer. And from that time, my lord, I am living a very pathetic life, my lord. The condition is so poor, my lord, that the person
You are the petitioner. Are you the petitioner?
I am for the respondent also. Private respondent, the employer also. Labor matter.
Who is for the petitioner?
Mr. Manish.
Call him. We'll fix it. Yes.
Next. Therefore, it not none of the sections are applicable under the petitioner's matter. Petitioners are not named in their no recovery. They were not put on PI credit, though they are in custody since long, and they have been implicated while they have been they were in jail custody in NDPS Patasi, in which they have been granted bail and except 2 amnesty by the coordinate bench. Then it is alleged that one co-accused confessed and then they were remanded, and also for the purpose of involvement, for the justified involvement, it is alleged that petitioner made the confession before the police. And it will also be considered that confession of co-accused or confession of accused cannot be used against him. Same and except I have gone through at night, entire case study, absolutely there is no material to connect the petitioner.
Yes, please.
Again, एक criminal incident है, बहुत petitioner और ट्रैक्टर 3 ट्रैक्टर चलाने का एलिगेशन है।
एविडेंस क्या है? आप तो आर्म्स भी रिकवर नहीं किए। इनका कन्फेशन स्टेटमेंट में था कि हम रिकवरी करा देंगे, कहाँ थी? नहीं की। क्यों नहीं की? वो भी तो नहीं किए ना। You have stated, they have stated that they can कहाँ पर है बता देंगे। वो भी तो रिकवरी नहीं हुआ ना। ये नंबर 1046 का 2026 कस्टडी बताइए। कस्टडी For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that neither the petitioner is named in the FIR, nor there is any recovery, and no TIP has been conducted. He has further submitted that the petitioner has been remanded in the present case while he was in custody in connection with NDPS case number 85 of 2025. And except confession statement, there is nothing against the petitioner. Counsel for the state has opposed the prayer and has submitted that the petitioner has one case against him of similar nature. He submits that the allegations are serious. However, it is not in dispute, even from the side of the state, that there is no recovery made either from the petitioner or on the confession statement of the petitioner. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the petitioner is directed to be enlarged on bail. एक petitioner है, दो हैं?
दो हैं।
Petitioners are directed to be enlarged.
From the daily list under heading for fresh filing, item 1, DA.23.04 of 2026.
आप नेम्ड भी हैं, आपके अगेंस्ट में एंटीसीडेंट भी है, डायरेक्ट एलिगेशन अगेंस्ट है। कुल्हाड़ी लिया और हेड इंजरी है, शार्प कटिंग कोई बात स्पेसिफिक नहीं है, काफी
Earlier, why for this petition I lost.
क्या नाम है उनका? अबुल अंसारी, जिसमें अबुल अंसारी के हाथ में कुल्हाड़ी, एनुल अंसारी के हाथ में फरसा तथा शिवानी कुमारी के हाथ में बैठी लेकर मेरे घर के दरवाजे का ताला तोड़कर अंदर घुस गए, राइट?
इंजरी रिपोर्ट में ये भी नहीं आया जो कि कॉज बाय
कस्टडी कब से?
स्टडी भी कर रहा हूँ
8/9/25। स्टेट क्या है? स्टेट क्या है? स्टार्ट नहीं हुआ अभी
लेबर का वो लगा था इसमें एडमिटेड पोजीशन केस earlier
and there are several cases pending against you. सब में बेल पे अच्छी BA नंबर 2394 ऑफ 2026। रिपीट ऑफेंस में दिक्कत है, बहुत दिक्कत है इस कोर्ट में। रिपीट ऑफेंस में निकालने के बाद और उनको लाइसेंस दे देते हैं फर्दर क्राइम करने के लिए। BA नंबर 2394 of 2026 for the learned counsel preparing on behalf of the party, the learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case and there is case and counter case.
Earlier हम लोग का केस है।
क्या चीज़ है?
हम लोग का earlier केस है। पहले हम
And
लोग उसके बाद
the case was registered by the petitioner prior to the present case. And the petitioner is in custody since 8/9/2025. The learned counsel for the respondents has opposed the prayer for bail and has submitted that there is direct allegation against the petitioner in the FIR itself. And the victim has suffered grievous injury. Grievous injury, and there are criminal antecedents against the petitioner, as recorded in the impugned order itself, which are of serious nature. After hearing the learned counsel for the parties and considering the direct and specific allegation against the petitioner, which is of serious nature, and also the criminal antecedent of the petitioner, this court is not inclined to allow the petitioner under this constitution. At least at this stage, you can file bail application every day.
Item 2 BA 2403 of 2026.
Sorry?
103 इंफॉर्मेंट को टेलीफोन एम्प्लॉय बताया कि हम एक अदर दो एम्प्लॉय आपस में झगड़ा कर रहे हैं और जिसमें कि हमारे पे एलिगेशन है कि हम उसको रॉड से मारा।
आपका तो CCTV फुटेज में भी पूरा है,
लेकिन उसमें CCTV का कंप्लायंस हुआ कि नहीं विदाउट डायरी
अभी मंगा दें। BA number 2403 of 2026. For the learned counsel appearing on behalf of the parties, counsel for the petition has submitted that, although it has been mentioned in the impugned order that the petitioner was that in the CCTV footage also, the petitioner was found while committing the offence. However, he submits that he is not aware as to whether the certificate under section 65B has been obtained by the police. Counsel for the state is directed to file a counter affidavit with respect to the aforesaid fact.
सेकंड चीज
कोई बात नहीं, अभी तो
नहीं
let the case diary be called for from the concerned court along with the criminal antecedent report.
प्लस एक चीज जो सीज आर्टिकल जो बोल रहे हैं कि
20 एक जो आप बोले हैं वही लिखाएं,
नहीं तो एक चीज और बोल रहे हैं
काफी चलिए
स्टेट फाइल करेंगे।
स्टेट फाइल वो जो यूजुअल ऑर्डर रहता है हम लोग का ऊपर नीचे हो गया 20 अप्रैल को रखें।
Item 3 BA 2405 of 2026.
काउंटर पे ध्यान दीजिएगा, स्टेट उनका 65B का सर्टिफिकेशन पे ध्यान देंगे।
The husband of the informer has committed suicide. So as per the allegation in that file, there was a love affair in between the daughter and the.
While you had come out on bail in the previous case, you had committed this offence.
No, I had not committed this one.
नहीं, as alleged.
एफआईआर दे दिए The earlier stage in
एक
which
सेकंड, पुराना एफआईआर का डेट बताइए,
पुराना एफआईआर का डेट उसका जजमेंट भी लगा दिया है।
बताइए ना, डेट खाली बताइए एफआईआर।
एफआईआर इज 2nd of December 2020।
2 दिसंबर 2020। बेल आपको कब मिला?
बेल हमको उसमें मिला है 13/7/2021।
13/7
उसका भी ऑर्डर
2021। और इस केस में इंसिडेंट कब का है?
इसका इंसिडेंट इज 8/12/2021।
8/12/2021। आपका एक्यूटल कब हुआ?
मेरा टोटल हुआ है 19th of March 2025।
19/3/2025। ठीक ही है ना? बेल के समय किए ना ऑफेंस एलिज्ड।
और 306 ये हस्बैंड सुसाइड कमिटेड। इनका एलिगेशन ये है कि इनकी जो बेटी है इनके साथ लोग
आप इनके घर में जाके कैसे इंटरेक्शन कर सकते हैं?
That's not the fact. Even
अरे
exaggeration
भाई,
is there.
बेल में फैक्ट थोड़ी देखेंगे, बेल में एलिगेशन देखेंगे।
Allegation of fact में सिमिलरिटी होना चाहिए। जो पहला एफआईआर हुआ उसमें बेटी बोली कि नहीं 19 साल की है, अपने एफआईआर में बोलती कि 16 साल की है। जब उनका एज असेसमेंट होता है 19 साल आता है।
Just a moment. Heard the learned counsel for the parties. The counsel for the state is directed to file a counter affidavit in this case with particular reference to the age of the victim as on the date of occurrence. कोई भी सर्टिफिकेट वगैरह हो सकता है, मिल गया होगा। पुराने केस में तो था नहीं, पूरा केस में तो था नहीं, पुराने केस में, राइट? Call for the case diary. And also the statement of the victim recorded previous case में। इस केस में भी तो हुआ होगा इनका स्टेटमेंट।
नहीं इस केस में नहीं हुआ, 306 का है।
इस केस में वो तो विक्टिम है, साथ में लड़की भी तो है ना।
नहीं इस केस में नहीं हुआ। 306
अरे भाई, लड़की का कोई स्टेटमेंट रिकॉर्ड हुआ होगा कि नहीं हुआ?
161 में हुआ।
हाँ, 161 में। Let the case diary be called for from the consent. 19. लड़की का स्टेटमेंट देखिएगा क्या है?
प्रीवियस केस में जो लगा दिया है तो उसमें नहीं दिया।
सॉरी?
प्रीवियस केस जो पहले प्रकरण सामने जिसका रेफरेंस ही दिया है उसमें 164 विक्टिम का हुआ, उसको भी अगर मंगा लिया जाता तो जो उसमें
उसमें टोटल हो गया, उसमें क्या देखना है?
तो वही दिखा रहे हैं कि 19 इयर्स ऑफ एज था, अपने फ्री विल से उनके साथ एलोप की थी और उनके शादी करना
फ्री विल से एलोप की थी एक बार, बट पेरेंट्स वर नॉट रेडी फॉर द वेडिंग। उसके बाद दोबारा भाग जाती तो भी कोई बात नहीं।
वो भी 306 कॉन्स्टिट्यूशन ऑफ 306 प्लस अमेंडमेंट
वी विल सी दैट
20
बी सी
कौन सा स्टेटमेंट है? 161 वाला
161 वाला स्टेटमेंट दे विल गिव स्पेसिफिक रेफरेंस।
Item 4 DA.25.03 of 2026.
I would 406 and 420 of the other. As per regulation, there is fraud of 79,000. Cash was handed over to the by the informant, and after that the titular transfer the amount in the account of the informant. That has
काफी है ना? The money has
actually as per fact, my lord.
there are antecedents
As per
also
FIR,
against you.
Antecedent is there, my lord. But as per FIR, my lord, the account holder is Rahul Kumar. हमने नहीं किया है. That has come in, my lord. And you appreciate the page, my lord. Page 33. For 33, my lord.
Bank account of Rahul Kumar.
Rahul.
He transferred it in your account.
नहीं. Rahul Kumar transfer in the account of the informant, my lord. I have not
Okay,
transferred.
Rahul Kumar transferred it in the account of the informant.
Informant. So I have no concern, my lord. I have no transfer the money, my lord. That has been transferred by the Rahul Kumar, that has come in FIR. That is a statement of the informant itself, my lord.
आप कैसे accused बने?
Page 33.
How did you become accused in the case?
Only on the basis of that I have given my PAN card to the informant at the time of transaction. That has only allegation. Otherwise, no transfer, nothing was done by me, and I have taken money, and no any receipt, nothing. Kindly appreciate my page 33. On
You see, the allegation is that you
Rahul
arrived,
Kumar.
just a moment, you arrived at the place of informant, then asked him to share the QR code citing medical emergency. Right? Pursuant to 79,000 was transferred in the bank account. Whose bank account?
Rahul Kumar.
ये जो ट्रांसफर है ये
FIR
FIR पढ़ी है FIR पढ़ी।
निवेदन पूर्वक कहना है कि मैं रमेश कुमार अग्रवाल स्वयं मैं कल्याण नगर अपने निवास स्थान पर प्रज्ञा केंद्र चलाता हूँ। हमारे यहाँ मनी ट्रांसफर एवं आधार कार्ड से पैसा निकासी किया जाता है। दिनांक 29/7/2023 को मेरे यहाँ मोहम्मद रिजवान पिटिशनर पिता स्वयं सो एड्रेस स्वयं सो का निवासी और उसका साथी स्वयं पैसा निकासी करने आए, जिन्हें मैं पहले से नहीं जानता था। रिजवान ने बताया कि मेरे परिवार में कोई बीमार है और हम लोगों को पैसे की सख्त जरूरत है। रिजवान ने मेरे केंद्र में लगे क्यूआर पर पहले ₹1 फिर 79,000 रुपए भेजकर मुझसे कैश ले लिया। बड़ा अमाउंट होने के कारण मैंने रिजवान से उसका पैन कार्ड ले लिया।
तो आपके पास, आप ही के पास ना ट्रांसफर हुआ अल्टीमेटली, तभी ना कैश ले लिए।
I have received cash and transferred the amount to the account of the informant. That is allegation. But as per page, my daughter, kindly appreciate the Rahul Kumar transferred the cash amount in account of the
क्या बोलना?
राहुल कुमार किया, हम नहीं किए।
क्या बोलना?
I am in custody matter.
इन्होंने
एक सेकंड, कब से कस्टडी?
राहुल कुमार
एक सेकंड, कब से कस्टडी?
11/12/2025 voluntarily surrender. I come to know and voluntarily surrender.
Yes, sir.
Tribal by my state.
Rahul Kumar transferred the amount in the
Amount.
name of the informant, and the informant gave cash to the petitioner.
No, that is not the QR पहले राहुल कुमार का QR में लिया ये आप ₹1 ट्रांसफर करते हैं
राहुल कुमार।
उसके बाद राहुल कुमार जो ट्रांसफर किया है ये पैसा, उसके पास क्या बोलते हैं
पेज आप देखिए ना 25 राहुल कुमार किया है। हम क्यूआर कोड राहुल कुमार का क्यों लेंगे? ये लिखा हुआ है आपका
QR कोड
स्टेटमेंट में लिखा हुआ है।
आप इतना
सॉरी
बहुत क्या बात है? आपको शांति से सुन रहे हैं ना? काफी है।
यस
बैठ जाइए, प्लीज सिट डाउन। बिना समझे ना मैं ऐसे ऑर्डर नहीं करते, भले हमको पूरा दिन लग जाए समझने। हाँ बोलिए। यस बोलिए।
अकाउंट में हुआ था वह
फ्रॉड वर्ड यूज करने से फ्रॉड नहीं होता। ये पेज नंबर 25 में देखिए, हमारे यहाँ मनी ट्रांसफर एवं आधार कार्ड से पैसा निकाला जाता है। दिनांक 29/7/23 को मेरे यहाँ मोहम्मद रिजवान पिता सचिन सर निवासी और उसका साथी सोएब पैसा निकासी करने के लिए आए, जिन्हें मैं पहले नहीं जानता था। रिजवान ने बताया मेरे परिवार में कोई बीमारी है और हमको पैसे की सख्त ज़रूरत है। रिजवान ने मेरे केंद्र में लगे क्यूआर कोड पर पहले ₹1 ट्रांसफ़र किया, ठीक है, फिर 79,000 भेजकर
मुझसे पैसा ले लिया,
मुझसे कैश ले लिया।
हाँ, कैश ले मुझसे ले लिया, ₹1 पहले भेज दिया और कैश भी ले लिया, ये इससे ले लिया। अब जिसके पास भेजा गया इसको बोला जहाँ भेजने के लिए वो जो पैसा गया है वो फ्रॉड का पैसा है। यही
Counsel for the state is directed to file a counter affidavit explaining bringing on record the transactions in connection with the money involved in this case. आपके पास आ गया है केस डायरी? देख द केस डायरी को।
स्टेटमेंट लगाया हुआ है, गवर्नमेंट का स्टेटमेंट लगा हुआ है।
कोई बात नहीं।
बैंक अकाउंट
किसमें?
आया
FIR में लगा हुआ है? आप लगाए हैं स्टेटमेंट?
मेरा के साथ
FIR के साथ जो
पेज 25 लास्ट माय लॉर्ड 1 2 3 4 लाइन में लास्ट 29/7/23 79,000 राहुल बाय का नोट बाय
पहले ₹1 का ट्रांसैक्शन
79
ये किसका बैंक स्टेटमेंट है?
उनका है गवर्नमेंट का भैया के साथ अटैच 35 को भी हम सर्टिफाइड को
सो इन्फॉर्मेंट के अकाउंट में
इम्पोर्टेंट है राहुल कुमार
ये तो क्लियर है, इसमें क्या
राहुल कुमार
लिखिए,
ने किया है
फिर से लिखिए तो for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. There is transaction of money from Rahul Kumar in the account of the informant, which and the statement of account is a part of the case. And so far as the petitioner is concerned, he has no connection with the transfer. Counsel for the state has opposed the prayer for bail. To this counsel, the petitioner submits that the petitioner is in custody since 11/12/20. After hearing the learned counsel for the parties and considering the nature of transaction as per the bank account, which is a part of the FIR itself, the petitioner is directed to pay enlargement.
Under heading for admission, item 5, BA 119901 of 2025.
Yes.
About 14 years old.
14 years.
14 years. Kidnapped by
Where is the petitioner? Pass over. कल भी था क्या ये केस? नहीं था ना कल? Pass over.
family request he lost. पासवर्ड जब स्टेट अप्रूव नहीं रहती थी तो उसमें पासवर्ड करके मौका दिया जा सकता है। कहीं 2-3 केस हमारा हम यहाँ पर पहुँचे और
तो एक चीज बता रहे हैं, देखिए पिटिशनर का तो कोई दूसरा जूनियर नहीं भी होता है। आपके यहाँ इतने स्टेट लोग रहते हैं, वो कभी बोलते हैं कि पास ओवर कर दीजिए? आप लोग का आपस में तो भाईचारा नहीं है। नहीं, हम भी हाथ जोड़ के विनती करते हैं कि आप अपने भाई बंधु को बोल के रखिए कि कोई स्टेट नहीं अपियर हो तो खड़े होकर पास ओवर का प्रेयर करिए। स्टेट तो सब एक है ना? हाँ, तो किसी को तो बोलना चाहिए ना खड़े होकर, राइट? बोलना चाहिए ना खड़े होकर। हाँ, तो बस ठीक है। पिटिशनर का इसलिए कर देते हैं क्योंकि हर एक पिटिशनर के काउंसिल के पास जूनियर नहीं होते और सब लोग बिजी रहते हैं। यही रिक्वेस्ट है, हमारा भी यही रिक्वेस्ट है कि आप अपने फ्रेंड्स को बोलिए कि कोई केस में कोई नहीं अपियर हो रहा हो तो खड़े होके बोलेंगे पास ओवर करने, तो हम मना नहीं करेंगे किसी को। चांस, वही चांस की बात कर रहे हैं।
Item 6, BA 12001 of 2025.
Santosh, he has been recovered from the and co-AP has been granted bail by the coordinate bail. Page 15 is the order. tribal magistrate and custody.
ट्राइबल बाय मजिस्ट्रेट से क्या मतलब है आपका कि 3 साल से ज़्यादा आपको सज़ा नहीं हो सकता है कैसे ऐसा मतलब है आपका तो आप गलत सोच रहे हो ठीक है
11/8/25 से कस्टडी में है।
FIR जरा पढ़ेंगे FIR जरा पढ़ें
आशीष निवेदन को कहना है कि मैं चंदन सिंह उम्र सचिन सर पिता सचिन सर पता सचिन सर निवासी हूँ वर्तमान में रंजीत निवासी खनान नगर तिलता थाना राजू जिला राजपुर किराएदार के रूप में रहता है दिनांक 4/5/25 को समय 9:30 बजे रात में अपने घर के साथ में पिकअप गाड़ी
आपकी गाड़ी रिकवर हो गई है इन्फॉर्मेट की कहाँ से हुई
को एक
को एक्यूज के पास से रिकवर
संतोष कुमार
इम्प्यून्ड ऑर्डर में है
उनके ऑर्डर में चासी साहब ने
आपसे जितना सवाल पूछ रहे हैं उसका जवाब दीजिए नहीं तो हमको काउंटर एफिडेविट कॉल करना इम्प्यून्ड ऑर्डर में कहीं है कि रिकवरी कहाँ से हुई
ये है कन्फेशन ऑफ द कोई
बस इतना ही लिखा है कन्फेशन ऑफ द
having considered submission party of his right to appear the petitioner in custody 8/25 in connection with the pertaining case it further transpired that during the course of investigation Maharama who is Santosh Kumar has confessed his involvement in the pertaining case. The prisoner is associated with the gang.
Heard the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the state. The learned counsel for the petitioner submits that the petitioner is not named in the FIR and the name of the petitioner has come in the confession statement of the accused, namely Santosh Kumar. And no incriminating article has been recovered from the possession of the petitioner. He has submitted that the bail application of the petitioner has been rejected primarily on the ground of certain criminal antecedents. है तो इसमें antecedent इनके अगेंस्ट इस केस रिकवरी भी नहीं है इनके पास राइट counsel for the state has submitted the petitioner submitted that संतोष कुमार के बेल में कैसे है कि nothing has been recovered from the possession of संतोष कुमार है ना बेल में लिखा हुआ रिकवरी कहाँ से इंक्लूड ऑर्डर में कहीं पता नहीं चला The petitioner has submitted that Santosh Kumar has been enlarged on bail. However, from the bail order of Santosh Kumar, it appears that it was submitted that nothing incriminating has been recovered from the possession of Santosh Kumar. Counsel for the state is directed to file a counter affidavit with particular reference as to from whose possession the stolen motorcycle has been recovered in the present case. Pickup van has been recovered in the present case, along with antecedent report and call for case study. दोनों जने एक ही बात बोलेंगे तब कैसे चलेगा इंक्लूड ऑर्डर से पता नहीं चल रहा कहाँ से रिकवर
Item 7, DA 121101 of 2025.
Yes, petitioner.
Your Lordship, the FIR is at page 15. The FIR is mentioned under section 363 and 363A. May I be permitted to read the FIR?
Yes.
नवोदय मैं बाबूलाल मुंडा पिता सर्जन नारायणपुर खरिया थाना अलीपुर जिला सरायकेला खरसावां में अपनी नाबालिग पुत्री संध्या मुंडा जिसकी
एज क्या बताया? FIR में एज कितना बताया? कटा हुआ इसमें
16 वर्ष
16 years. प्रोसीड.
आपको यह सूचित करना चाहता हूँ कि 19/7/18 को सुबह लगभग 6:30 बजे मैं घर से अपने कुछ निजी काम से निकला था। लगभग 12 बजे दिन में जब मैं अपने घर लौटा तो यह पाया कि मेरी नाबालिग पुत्री संध्या मुंडा तथा उसका पुत्र जिसकी उम्र लगभग 4 महीना है घर से गायब है। इसके बाद मैंने लगभग 2-3 अलग-अलग स्थान पर उन दोनों को ढूंढने की कोशिश की पर इन दोनों का कुछ पता नहीं चला। आज सुबह मैंने अपने कमरे के बिस्तर के नीचे दबा मेरी पुत्री संध्या मुंडा का पत्र पाया जिसमें यह लिखा है कि चंदन मंडल, सुमन मंडल, शोभा मंडल एवं नेहा राय द्वारा उसका अपहरण कर लिया गया। यह सभी लोग राउरकेला स्टेशन के पास उड़ीसा के रहने वाले हैं। सेकेंड पार्ट ऑफ द एफआईआर, आपको यह सूचित करना भी उचित समझता हूँ कि इससे पूर्व में भी दिनांक 5/12/2017 को मेरी नाबालिग पुत्री संध्या मुंडा को चंदन मंडल द्वारा अपहरण कर राजस्थान के रहने वाले किशन अग्रवाल एवं उसके पुत्र मुकेश अग्रवाल के हाथ लगभग 5 लाख रुपए में बेच दिया गया था तथा इसकी प्राथमिकी भी दर्ज कराई गई थी, जिसके बाद दिल्ली महिला आयोग एवं राजस्थान महिला आयोग के हस्ते से दिनांक 6/2/19 को किशन अग्रवाल एवं मुकेश अग्रवाल के निवास स्थान गाँव जिला झुंझुनवाला तहसील राजस्थान से मेरी नाबालिग बेटी संध्या मुंडा को गर्भवती अवस्था में छुड़ाया गया था। इसके बाद से लगातार मुकेश अग्रवाल द्वारा मेरी मोबाइल संख्या पर मुझे जान से मारने की धमकी दी जा रही है एवं मेरी नाबालिग बेटी संध्या मुंडा को दोबारा राजस्थान पहुंचाने का मतलब देयर टू पार्ट ऑफ एफआईआर। दिस रिलेशन इज अगेंस्ट
वो पुराने वाले FIR में क्या हुआ?
उसमें ये द सन ऑफ द पिटिशनर वाज मेड एन एक्यूज्ड मुकेश अग्रवाल हैज बीन गranted bail मैरिज फ्रॉम द ओडिशा हाई कोर्ट।
नहीं ये जो पहले राजस्थान लेके गया
उसमें बेल हो गया। नाउ ओनली
उसमें बेल हो गया।
मैरिज
वो तो अलग कहानी है।
अब वो अलग कहानी है।
इसमें
इसमें फिर से बता रहे हो
इसमें एक्यूज्ड कौन है?
इसमें my name is not there in the FIR also मैरिज।
Yes,
I
it
am
is not.
Kishan Lal Agarwal,
Kishan
father of Mukesh Agarwal।
Father of
Mukesh Agarwal। There is no allegation in the FIR against this petitioner, Your Worship. And the FIR is into two-fold, Your Worship. The informant talks about one incident of 2017 कि उसमें हमको राजस्थान ले जाए गए थे और उसमें ऐसा so that case is for that a separate case has been registered in Odisha. Now this present FIR is concerned, there is nothing against this petitioner, Your Worship, and he is in custody since 14th October 2025. And matters may also consider that there is a delay of 1 year in lodging of the FIR. Informant says that मैं चाहता हूँ कि 19/7/18 को सुबह लगभग 6:30 बजे and the date of FIR में kindly receive my 22/7/2019 after a lapse of 1 complete year of relation.
Case diary has stated that I filed a counter in para 58 of the case diary, 161st statement of duty, and as well as in para 415 of the case diary. In the two sets of case diary I have, but the same may be verified below also. First of all, page 50.
Well, the FIR is in two-fold, Your Worship. First part is of 2017. For that, a separate case has been registered.
Para 58, a statement of 164 of the victim. Clearly stated that the involvement of police institution is there.
Well, there is a second paragraph also in that 164 statement.
इसके 5/12/17 का ही बात कर रहे हैं।
5/12/17 के लिए रिलेशन मतलब दूसरा FIR हुआ है स्टेट ऑफ उड़ीसा। Only because this petitioner happens to be the son of Mukesh Agarwal, Your Worship, I have been implicated in this case. Second part is different, Your Worship. For that, FIR has been registered in Odisha, in which the son of the petitioner has been granted bail. Son of this petitioner and this lady, they stayed for 11 months together in Rajasthan. They were married, that has come in the
क्या स्टेज किस
चार्ज
एक तो 415 में CWC का स्टेटमेंट है, इसी में 450 स्टेटमेंट CWC taken before the CWC as Sundargarh, Odisha.
Odisha that
In the same case.
there is a delay of 1 year in lodging of the FIR. And 4 allegations are there. One of the allegation is of the case for which a case has been registered in the state of Odisha. Entire allegation is against the son of the petitioner. Mukesh Agarwal.
लड़की का स्टेटमेंट बहुत ज़्यादा है आपके खिलाफ.
Irrigation is nothing against this petitioner. That is of that incident for which a separate case has been registered.
No, for this case also.
No, Irrigation. I read the
For this case
164.
also, you read the 164.
164 statement.
Just a moment, Kishan Lal Agarwal ना पढ़िए 164 स्टेटमेंट पढ़िए.
पैराग्राफ 58.
हाँ पढ़िए.
दिनांक 19/7/19 को मेरे पापा कुछ काम से टाटा गए हुए थे. मैं घर पर अकेली थी. फिर एक घंटा बाद चंदन मंडल जो मेरे जीजा है और किशन अग्रवाल जो राजस्थान के रहने वाले मेरे फोन पर उनका फोन आया. फिर चंदन मंडल और किशन अग्रवाल मुझे फोन कर धमकी दिए कि अगर तुम नहीं आओगे तो तुम्हारे पापा का मर्डर करवा देंगे. फिर मर्डर मैं डर गई तो वे लोग मेरे घर सरना टोली कमरिया ब्लैक वैन में आए.
वो लोग आए.
हाँ वो लोग आए.
हाँ आप ही का नाम ले रहे हैं किशन लाल अग्रवाल. का नाम
उस ब्लैक वैन में मेरे जीजा जी चंदन मंडल दीदी सुबह मंडल शोभा मंडल मेरी बट रिलेशनशिप शी हैज रिटन अ लेटर
आप बट मत पढ़िए, आप पूरा ही पढ़िए, बीच में मत घुसाइए कुछ.
मेरी बुआ बड़ी भाभी दौरा और किशन अग्रवाल वैन में मौजूद थे. वो लोग मुझे
किशन अग्रवाल वैन में मौजूद थे.
वे लोग मुझे गमरिया से सुंदरगढ़ उड़ीसा ले गए और CWC के चेयरमैन रामचंद्र बेहरा के पास ले गए. उस जगह CWC चाइल्ड वेलफेयर कमेटी उस जगह पर मुझे लाकर किशन अग्रवाल CWC के बेहरा साहब को बोले कि मैं लड़की को लेते आया हूँ, आप जो करना है कीजिए. उस दिन बेहरा साहब मुझे शाम को दिशा होम में रखवाए शेल्टर होम. उसी दिन लाठी कटा पुलिस वहाँ आई और मुझे बोली कि SP महिला पुलिस के पास ले जाएंगे. वहाँ पेपर पर हस्ताक्षर करवाया. फिर मुझे मजिस्ट्रेट के पास ले गए और मेरा वहाँ बयान हुआ. फिर मेडिकल चेकअप हुआ. उसके बाद मैं दिशा होम आ गई. वहाँ एक सप्ताह रहने के बाद आश्रम लाया गया. फिर मेरे पापा आए और मुझे गमरिया ले गए. So this is with regard to the FIR relation.
That's right.
You receive now
She says
your
statement against you that you called her up, you were there in the van, you took her to Odisha. Her statement was recorded.
Kindly see the FIR for a minute, madam.
FIR तो मिसिंग का है.
मिसिंग है. उसमें लड़की उस फादर द इन्फॉर्मेंट सेज कि मेरी बेटी एक लेटर लिख के गई थी जिसमें ये लिखा हुआ है कि सच ये उसके जीजा जी सुमन मंडल चंदन मंडल ये लोग हमको किडनैप करके ले गए. The name of the petitioner is not there.
किडनैप करते समय जो है लेटर भी लिखा.
No ma'am, that is not there. She has given the name of this co-accused person's relationship, but she has not taken my name in that. Unless the admitted case is that she was married to my son. They have stayed together for 11 months, and now this case is being lost. They have stayed together for 11 months. That is not.
How did this minor girl got married to your son and was staying with you in Rajasthan?
Yes, that's coming that you not.
No, that's right. But how?
They have stayed together in relationship.
They have stayed together means what? Marriage is valid.
Her age has been assessed as 19 years relationship. Medical examination, her age has been assessed as 19 years.
रास्ता में कुछ दे दिया गया जिसके बाद में
ये सब
उल्टी होने लगा.
ये वो तो जो उसके लिए separate FIR. Malas for that separate FIR is there. For that separate FIR is there, malas. As far as this allegation, this FIR is concerned, there is no allegation in relationship.
ये कहानी अभी खत्म नहीं हो रही है. FIR पर FIR होते जा.
एक पहले हुआ था जो 2017 में. And you should delay of 1 year in lodging of the FIR. 1 complete year relationship.
Time barred हो गया FIR.
Like that is not there, but the delay is there in relationship, and there is no whisper about this petitioner in the FIR matters. Not even named in the FIR. And relationship charge has also been framed. From the FIR itself, there is no allegation in relationship. And 164 also the subsequent part talks about the prior FIR in relationship, which has been registered in the state of Odisha. And the age of the victim has been assessed as 19 years. In 2019 itself, from the date of occurrence, her age has been assessed as 19 years. I may be permitted to show that from the interview noted. Her age has been assessed, paragraph 90 your edition. May kindly see paragraph 90 of the case diary for a minute. Her age has been assessed at 19 years by the medical officer. So she is not a minor even.
Para number?
Paragraph 90 medical edition of the case diary. The doctor has, she was medically examined your ladyship.
On
Paragraph
what
90.
date? On what date?
On 15 2019 itself. Date of FIR. Paragraph 90, next page your edition.
4/8/20 का है।
हाँ, she's में FIR में
बताइए कहाँ लिखा है?
पढ़ देते 19 years.
कहाँ लिखा है?
Last page में 90, paragraph 90 में. Age about 19 years in page number, subsequent page also, your edition. Age about 19 years. जहाँ पे opinion लिखा हुआ है your edition. Last page of the medical report. So she was admittedly major your edition. She was not even a minor, and delay of FIR in your edition 1 year after the FIR has been lodged. No allegation against the petitioner in the FIR. They have admittedly stayed, the son of the petitioner and this girl has stayed for 11 months at Rajasthan together.
ये यहाँ से उठा के उड़ीसा क्यों ले गए?
उड़ीसा में 2017 में जो घटना हुआ, जो बच्ची थी उसको नाश्ता में कुछ दे दिया गया था, जब उल्टी होने लगा वो लोग उसको
नहीं, एक सेकंड, किडनैप करके ये लोग उड़ीसा क्यों ले गए?
उसकी लड़की को जो दीदी और जीजा जी ये लोग लेकर के
क्यों उड़ीसा में, वो भी CWC के पास?
इनके पापा को 5 लाख रुपए बेचे ये है 415।
एक सेकंड, आप हमको ये बताइए, किडनैप करके CWC एक अथॉरिटी के पास क्यों लेके गए?
CWC के पास, सॉरी 17 को जो किडनैप करके उड़ीसा ले गया।
17 का कहानी बंद करिए, उसका तो कहानी दूसरा चल रहा है, उसका तो अलग FIR।
शादी के बीच में राजस्थान
हम मान लेते हैं, हम वो सब 17 का कहानी मत सुनाइए, हमको ये बताइए कि ये लोग इनको उठा के उड़ीसा क्यों लेके गए? उठा के ले जाते राजस्थान, कोई अथॉरिटी के पास लेके गए? आपको लगता है कोई स्टेटमेंट वगैरह रिकॉर्ड कराने के लिए लेके गए? यही है ना कहानी? 164 में बोल रही है कि अथॉरिटीज के पास लेके गए, CWC के पास लेके गए, मजिस्ट्रेट के पास वहाँ बयान रिकॉर्ड कराया, क्योंकि इसका बयान नहीं रिकॉर्ड हो रहा होगा, पता नहीं चल रहा होगा कहाँ है। एट बेस्ट यही ना है। अरे नहीं, अपने बयान में बोल रही है CWC अथॉरिटीज के पास लेके गए, इस बीच तो कोई ऐसा और कुछ भी नहीं बोल रही है। लेके गए वहां पर, अथॉरिटी के पास इसका बयान दर्ज कराया, मजिस्ट्रेट के पास इसका बयान दर्ज कराया, ठीक है ना? हमको लग रहा है कि बयान दर्ज कराने के लिए नहीं आ रही होगी, इसीलिए इसको लेके गए। एलिगेशन तो लगा दिए कि 5 लाख रुपए लेके गए, 1 साल का डिले है FIR में। आपकी बच्ची 1 साल से गायब है, 1 साल बाद FIR होगा, 1 year. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that there is an allegation that the victim was kidnapped in the FIR by others, including the present petitioner, and there is also further background mentioned in the FIR itself in connection with one occurrence of 2017. When the victim was allegedly taken to Jhunjhunu in Rajasthan, and she got married with the son of the petitioner. He has further submitted that petitioner has been falsely implicated in this case. The age of the victim has also been assessed to be 19 years. The learned counsel for the state has opposed the player and has referred to the statement of the victim recorded under section 164 of CRTC, and he submits that the petitioner along with others had taken the victim to Child Welfare Committee in Odisha, and then her statement was recorded, and then she was sent to shelter home at Odisha, and ultimately she was recovered from shelter home upon intimation being given to the informant of this. The counsel for the state has submitted that the petitioner is in custody since
14/10/2025.
14/10/2025, and even if the statement of the victim is taken into consideration, then also she was taken to shelter home, and for the purposes of getting a statement recorded, and a statement was also recorded before the magistrate at Odisha. And upon medical examination, she was found to be major. He has also submitted that so far as the case registered in the year 2017 is concerned, the petitioner has already been enlarged on bail. Is that correct?
Son of the
Son of the petitioner has been enlarged on bail. You are also an accused in that case?
I'm not aware of that. I'm actually not.
Not aware. बेटा को हो गया.
हाँ बेटा है. He is sitting in the court. Son is.
After hearing the learned counsel for the parties and even considering the statement made under section 164, the victim was allegedly taken to CWC in Odisha, where her statement was recorded, and her statement before the magistrate was also recorded. And apparently, one FIR was registered in 2017. There is delay of registering of the case by 1 year. The petitioner is in custody since
14th October 2025.
14/10/25. Charge sheet submitted.
Charge.
Charge sheet has been submitted and charge has already been filed. Considering the aforesaid facts and circumstances, the petitioner is directed to be enlarged on bail.
Item 8, DA.25.03.2026.
Offense section 140 clause 1, 103 clause 1 and 238 of the PNS. So far as the allegation is concerned, Lordship, the FIR in the FIR, Lordship, the petitioners are not named. 5 persons have been named, Lordship: Devki Devi, Durga Devi, Govardhan Khewat, Neetu Devi and Vasudev Khewat. Now Vasudev Khewat, Lordship, who happens to be the main assailant, who has committed the murder, Lordship, on his confession, our name has come. He has been granted bail by the court bench of this honorable and extra 2 base 15, Lordship.
council further stated directed to file counter affidavit.
It was called for also for the last occasion.
Counter affidavit तो नहीं है इसमें.
रिसीव की जाएंगे
Counter affidavit. Is directed to file counter affidavit. केस डायरी से हो जाएगा काम.
Nothing is there.
सेक्रेटरी समझ आता है
एक्यूटल करवा देते हैं. यही से एक्यूटल करवा देते हैं. Nothing is there. कुछ
कुछ
है तभी ना केस है.
उसका bail हो गया, that is
We'll see that.
on record.
Council, एक second, फिर से. Council for the parties are present. Council for the state has submitted that the case diary has been received. उसको जरा मार्क करके दे दीजिए. He is directed to submit the case diary to the court posted. केस डायरी देखेंगे इत्मीनान से तब आप मार्क कर दीजिए आपको क्या क्या है.
मार्क कर दीजिए. Item 9 BA 417 of 2026.
Under section 302 against unknown persons. The allegation, the informant states that his son had gone to watch orchestra and he had gone to another village. When he returned from another village, he was informed that at night, when his son was standing along with another deceased person, two unknown persons had came in the bike and shot both persons.
Including the informant's son.
Informant's son. The two shots were fired, both the person died also. He went in the morning and recovered his son leadership in the morning.
How many witnesses have been examined so far?
Leadership only 2 witnesses.
No, this is as on 1/11/25.
Leadership even today. I was just in the morning leadership I had checked. The last witness that was examined was in July 2025 leadership, 31st July 2025. And till date leadership got from the order sheets that is uploaded online transpires that bailable warrant has been issued to the witnesses, but none of them has come forward leadership and SR of the bailable warrant is pending. The two witnesses that have been examined leadership,
Council for the state is directed to file a counter affidavit in this case. It has been submitted by the petitioner that witnesses are not coming, witnesses are not being produced by the prosecution before the court, and the last witness was examined sometimes in the year in the month of July
31/7/2025
on 31/7/2025.
leadership. That which is apparent from the online record.
Call for the case.
Case diary was called leadership.
Case diary is here.
Yes.
आपका counter
Perhaps the state
state as well. I've seen two witnesses.
leadership.
They have to, they have to justify your.
And the leadership.
20 थोड़ा दिन रुक जाओ. Case diary. We'll see what is there against you. That FIR is against unknown. ऐसे बिना देखे. Murder का case है. Counterfeit कर दीजिए.
Item 10 BA 534 of 2026.
Yes, ma'am.
NDPS or customers are permitted to read the FIR information. Page 16. सविनय निवेदन है कि मैं सजन सच मैं वर्तमान में बरियातू थाना रांची में पुलिस अधीक्षक के पद पर स्थापित है. दिनांक 23/11/2025 समय 23 बजे गुप्त सूचना मिली कि बरियातू थाना अंतर्गत जनता मीट के संचालक टूटू कुमार साव के द्वारा अवैध नशीली पदार्थ की बिक्री किया जा रहा है, जिसका प्रयोग रामकोट के द्वारा नशा के रूप में किया जाता है. इस आशय की सूचना वरीय पदाधिकारी को दिया और वरीय पदाधिकारी के निर्देशानुसार एवं छापामारी दल का गठन किया, जिसे मेरे साथ सचिव शामिल किया गया और थाना के पीसीआर गाड़ी के सूचना के सत्यापन एवं आवश्यक कार्रवाई हेतु समय 23:40 बजे जनता में दुकान पहुंचा तो देखा एक व्यक्ति के द्वारा पुलिस को देखकर एक कार्टून को छुपाने की कोशिश कर रहा है, जिसे खोलने को कहने पर दुकान में उपस्थित 2 व्यक्ति भागने की कोशिश करने लगे, जिसे पुलिस बल के द्वारा पकड़ लिया गया और नाम पूछने पर उन्होंने अपना नाम टूटू कुमार और मैं टूटू कुमार जिला से जो खुद दुकान का मालिक तथा लिच्चू महतो
झालरा करोलिया बताया, जिसमें 2 साक्ष्यों सचिन के जमा तलाशी देते हुए टुटू कुमार साव और झालरा के समर्थक द्वारा छुपाए जा रहे कार्टून को अपने कब्जे में लेकर विधिवत तलाशी क्रम में कार्टून को खोला तो देखने पर कार्टून के अंदर 20 बोतल विंग्स कंपनी कॉफ सिरप प्रत्येक 100 ml पाया गया। बरामद दवाओं के संबंध में कागज मांगने पर दुकान मालिक टुटू कुमार साव को इतना देते कि कोई कागज प्रस्तुत नहीं किया, ना ही कोई संतोषजनक उत्तर दिया। पूछताछ दौरान के पकड़ाए गए दुकान मालिक टुटू कुमार साव इतना बताया कि सभी सिरप बोलिया रांची निवास धीरज नाम के व्यक्ति से खरीदते और बेचकर मुनाफा कमाते हैं, जिसके प्रयोग लोग नशा के रूप में करते हैं। तत्पश्चात बरामद सभी सिरप का विधिवत जब्ती सूची बनाया गया। जब्ती सूची की एक प्रति दुकान के मालिक टुटू कुमार साव इतना गुटखा और सिरप नशा के रूप में प्रयोग को सील कर अपने कब्जे में लिया। साथ ही औषधि निरीक्षक को जांच हेतु सूचित किया। जब सभी सिरप एवं वहां के पकड़ाए दोनों व्यक्ति थाना सिरिस्ता पर बैठाया, सिरप को थाना मालखाना में रखा। इससे बहुत इम्पोर्टेंट रखा। तत्पश्चात औषधि निरीक्षक रांची श्रीमती आशना का रिपोर्ट आना है, जिन्होंने बरियारपुर थाना ज्ञापन की सूचना के माध्यम से आवेदन लेकर बरामद दवाओं को अपने समझ सील अवस्था में प्रस्तुत किया गया। उन्हें जांच कर जांच प्रतिवेदन उपलब्ध कराने के अनुरोध किया। औषधि निरीक्षक द्वारा अपने कार्यालय के पता खींचना के माध्यम से एक प्रतिवेदन उपलब्ध कराया, जिसमें उन्होंने उल्लेख किया जब्त की गई फॉस्फेट एंड
आपकी दुकान में बिक रहा है?
मेरी दुकान में नहीं बिकता।
टुटू कुमार
ऐसा कि NDPS के अंतर्गत NDPS इज अ फुल एक्ट। इसमें सर्च एंड सीजर का प्रोविजन दिया है। पुलिस can't go and seize like this and मालखाना में नहीं रख सकता if it is under NDPS Act. If your lordship turns to page 50, section 50, क्योंकि इनका अपना कहना है कि पुलिस छापामारी किया और पुलिस जो है अपने मालखाना में रखा, वो ये कर ही नहीं सकता।
क्या पढ़ा है?
53
Section 53.
Yes, Mediation.
Yes.
Power to invest officers of certain departments with powers of an officer in charge of a police station.
53 is the rules one. Just a minute.
5.
Yes.
The central government, after consultation with the state government, may by notification published in the official gazette, invest any officer of the Department of Central Excise, Narcotics, Customs, Revenue Intelligence, or any other department of the central government, including paramilitary forces or armed forces or any class of such officer with the power of an officer in charge of a police station for the investigation of the offences under this Act. The state government may by notification published in the official gazette invest any officer of the Department of Drugs Control, Revenue Exhaust or any other department, any class of such officer with the power of an police station investigation. तो सबसे पहले तो इनको ये सीधा पुलिस नहीं कर सकती। और एक और सेक्शन 50 देखिए, ये भी तो करना पड़ेगा। तो उसी पेज में मैडम सेक्शन 55 उसको भी देखिए, उसके बाद सेक्शन 50 Police to take charge of Article C.
मैडम क्वेश्चन फाइल कर दीजिए, पूरा केस क्वेश्चन हो जाएगा विदाउट jurisdiction.
मेरा जो डिफेंस
बेल की बात है ना मैडम, बेल के बात में बेल में इतना नहीं सुना नहीं सकता. The entire case is without jurisdiction. The search, seizure, everything is without jurisdiction. It's a case for quashing. लेकिन बेल में हम इतना नहीं दे सकते, ना ही हम इसमें कोई pronouncement कर सकते हैं, because that will affect the trial. There's no possibility of this kind of adjudication in a bail matter. Quashing में, of course, quashing में the court will have to see.
Then you are released here, I have already an argument. My specific case is Your Lordship, the petitioner, number one, sir, Chowmin Khela. He does not
Petitioner number one is running a shop.
ठेला चाउमीन का ठेला, चाउमीन और रोल बनाता है, ठीक है, और वहाँ पर बहुत आदमी रहते हैं. So it is not that he is a mutton shop owner and he was right.
He is not a mutton shop. He is not the mutton shop.
He has no criminal activity. And he has nothing to do with the seized cough syrups. And petition number two is his assistant. और ये हम स्पेसिफिकली दिए हैं पैरा 16 में हम लिखे हैं कि उसको नॉट कवर फ्रॉम द पोजीशन और फ्रॉम देयर
क्या बोलेंगे?
Yes, sir. Admittedly, Lord, the commercial quantity of cough syrup has been seized from the premises of the petitioner number one. On seeing the police, Lord, petitioner number one as well as petitioner number two, who is the assistant, Lord, started fleeing away from the place. They were arrested, Lord. And Your Lordship, the drug inspector was also called, Lord, at the place. And thereafter, the drug inspector in the presence, they were sealed, and the drug inspector has also submitted the report, verifying, Lord, that it is a Lord H1 category. It is a drug of H1 category which is prohibited, Lord, and it cannot be sold, Lord, without the prescriptions of the medical practitioner. And it is number two is concerned, he is also having the criminal activity of the similar nature, Lord. Kindly see, Lord. Case number two, Mariato PS case number 131, UA 269, 490, 420, 120, Section 3, Epidemic Disease Act, 51D, Disaster Management Act.
The number of
Mariato PS case number, Lord, the drugs and the NDPS.
Okay.
Counterfeit case.
Petition number two is there. Petition number one.
And in the case of the narcotic, Lord, it is a consent possession, Lord, it is below sign up 1 and 4.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is not the owner of the meat shop where there is alleged recovery. Rather the petition number one.
It is number one का addition, वो गलती से टू लिखा गया है, it is one का addition.
One का
Affidavit तो petitioner number two
वो लिख गया है, डायरी में लगा है,
डायरी में दिखा है।
उसकी जगह टाइपिंग है।
टुड्डू कुमार साहू का।
Yes,
He is petition number two. But they have
Petition number one.
हाँ, ऊपर काउंटर में दिखे थे petition
गलती से
number
लिखा
two.
गया है।
इसीलिए हम
तो आपके ऊपर केस है तो आपको तो पता होगा ना, आपने लिखा है क्या आपका कोई क्रिमिनल एंटीसिडेंट?
नहीं, हम कुछ नहीं लिखे। ये काउंटर में दिए हैं कि petitioner number one has no.
मैडम गलती सबसे होता है, केस डायरी उनको दिखा दीजिए, she should be satisfied.
I'm satisfied.
The learned counsel for the petitioner has submitted that the petitioner is only running a thela and is not the owner of Janata Meat Shop from where there is alleged recovery of 20 bottles of 100 ml Vincelix cough syrup. She has further submitted that the procedure prescribed under Narcotic Drugs and Psychotropic Substance Act 1985 has not been properly followed, and no case is made out against the petitioners. So far as petitioner number 2 is concerned, he is the assistant of the petitioner number 1 in running the tiller. The Learned Council for the state has opposed the prayer and has submitted that commercial quantity of objectionable material has been recovered from the possession of the petitioners, and petitioner number 1 has 2 criminal antecedents whose reference has been made in paragraph number 57 of the case diary, which has been produced before this court, and the counsel for the petitioner has also gone through the criminal antecedent report of the petitioner number 1 during the course of hearing. The counsel for the state has submitted that it has been inadvertently mentioned in the counter affidavit that the criminal antecedent is against petitioner number 2 and not petitioner number 1. After hearing the learned counsel for the parties and considering the alleged recovery of commercial quantity of objectionable material from the possession of the petitioners, and petitioner number 1 having criminal antecedents, that which this court is not inclined to enlarge the petitioners on bail instead.
Okay.
Passover case item 5, BA 11991 of 2025.
Yes, petitioner. नहीं है petitioner. In spite of repeated calls, the petitioner is absent. Counsel for the state is present. इनको एक सॉफ्ट कॉपी फॉरवर्ड करिए. Office is directed to forward a soft copy of this order to the counsel for the petition.
लेकिन आइटम 1 मेंशन
कोई बात नहीं, पाठ नहीं करेंगे.
From the supplementary list, under heading for final disposal, item 3, FK 322 of 2023.
ये तो आपने रिट का फाइल दे दिया है.
कौन सा?
Before I proceed with the matter, I would like to point out, since the matter related to cooperative society and cooperative society has not met party in this case, that will not the bylaws of the cooperative society is required to be brought to the and secondly, the authority which has
तो आप क्या करना चाहते हैं? You are the dependent, no?
I'm the
Sorry?
yes, I'm
You are the dependent. क्या करना चाहते हैं? Yes, respondent, you tell us. The property is of cooperative society. The agreement, the deed which was supposed to be registered, the cooperative society had also joined in that deed. Right? Why is cooperative society not a party? And how this decree will be executed? They are necessary party. It is their property. Then, you tell us, how will this deed be executed?
The deed was being registered
cooperative society is not a party. And in the meantime, it seems that they have dealt with the property also. Right?
They have allotted.
So they have allotted it to somebody else, whatever. Now this particular property has been dealt with by the cooperative society. You cannot bind the cooperative society that they will be bound by decree or they will be bound by the principles of lis pendens because they are not a party in this proceeding. Admittedly, the deed was never executed in your favor. Deed was never executed in your favor, although you were allotted with them. Right? And then how this relief can be granted to you? Something very serious. Why cooperative society is not a party in this proceeding? Although this issue has not been raised, but in the first appeal you will see this. They are necessary parties. They are not. Are they or they are not? हर चीज के लिए यस मत बोलिए. अगर आप हाँ बोल देंगे ना तो आपका केस अलाउ कर देंगे इनका केस 1 मिनट. The deed which was to be registered and which has been taken away by the defendant, who is the applicant before this court, cooperative society had given a consent.
No, there was no consent. The defendant had unilaterally taken away the.
No, unilaterally taken, but in the deed, cooperative society is a signatory. आप देखिए, see your plate. You see para number 13.
After grant of permission by the cooperative society, both the parties got a deed of transfer of leasehold interest, respect of cooperative plot number 83, made and prepared and presented the same for registration in the office of the district sub-registrar, Baruchas, on 3/8/15, duly signed by both the parties as well as countersigned by the secretary of the cooperative society.
And you have not made him party. इसका क्या कॉन्सिक्वेंस होगा? सोच के बताइए भाई, ऐसे नहीं. What is the consequence of this? You should seek instructions and consult somebody if you are not able to figure it out yourself. Who is your senior? तभी आपको आर्ग्यू करने बोलते तो आप करते हैं. इनका आर्ग्यूमेंट हो गया.
Just one interest, even so that I can take instructions. Then I'll be moving with the system.
When will he be back?
I think Friday.
Friday is day after tomorrow. Friday को तो रामनवमी है. So पार्टनर मैटर्स को इतना दिन तक हम पेंडिंग नहीं रख सकते. Did you take any objection on the point of non-joinder of necessary party?
Our distributed in the board of directors, not the secretary.
आपसे क्या सवाल पूछ रहे हैं, आप क्या जवाब दे रहे हैं? Did you take any objection on the point of non-joinder of necessary parties? Where is it? बताइए ना कहाँ है? Written statement में दिखाइए ना कहाँ है? Show me from the written statement. इतना blank रहेगा तो कैसे होगा?
This has not been taken by the but since the property belongs to the society, by law, cooperative society is being guided by the law, and not with the guidance of the secretary, and give your the defended minor. All the charges have been made minor. But when I gone through the biological information, now I have related to the board of directors. Paragraph 47 of the bylaw.
आप कहाँ से बायलॉज बायलॉज एग्जिबिट हुआ है क्या?
नहीं मालूम, इसी
फिर आप कहाँ से पढ़े?
इसलिए हम बोल रहे थे कि इसको
नहीं ऐसा
I've been
नहीं।
permitted to block it on secretary is not married. Secretary is not empowered to do anything. Bylaw does not permit him to act under such situations.
See, I'll tell you one thing. ये रीट पिटिशन नहीं है ना, आप कुछ भी बोलेंगे। जो चीज़ हमारे पास रिकॉर्ड पे नहीं है, ना तो आप वैसा कोई बहस करिएगा, ना परमिट करिएगा। आप अपने पास रखे रहिए कोऑपरेटिव सोसाइटी का बायलॉज। वी डू नॉट डू राइट। फर्स्ट अपील, we will not travel beyond the records. Whatever is there in the records, we are going to be guided by the records only. The submissions without any foundation cannot be entertained. Yes, sir. You have completed your argument. What else have you to say? आप अपना written submission बनाइए. There is no clarity in your argument. I understand what is the problem, but you have to make out your own case, no? I'm not here to help either parties. Am I supposed to do that? Yes? तो ब्लैंक मत रहिए, आपको करना क्या है ये बताइए। मंडे ये जो डीड आया है यहाँ पर IMA की सप्लीमेंट्री में, दिस इज डीलिंग विथ विच प्रॉपर्टी? 183 or 83? 186.
That has been allotted to somebody else.
And you are fighting for which property? You are fighting for 186.
83 months. I was allotted 186. However,
now you have been allotted 186. You want in exchange to get 83.
Yes.
Now your property has now been allotted to somebody else by the cooperative society.
Yes.
So
The rate is also pending regarding this.
How are we concerned with the rate? Now cooperative society has allotted that property to somebody else. Correct? Now once they allot the property to somebody else, then how this order will be executed?
With the permission of the cooperative society, only the exchange of the plots was already sanctioned by the cooperative. So according to the cooperative society notes, even the electrical meters that has been installed in plot number 83 is in mining. That has been, the cooperative society has agreed that 83 plot belongs to me.
But cooperative society is not a party. Right? So now there is no question of cooperative society giving any consent because they have already dealt with the property. Was your allotment cancelled?
Since they have allotted it to somebody else, it is.
They must have cancelled it. So your property, there is no surviving property with you to transfer it to them, isn't it? Your property was to be exchanged with the property of the dependent. You have got a decree, right? That exchange deed will be executed. Now that property does not survive in your name.
We have also challenged the cancellation of the
Allotment. Where have you challenged it?
The separate writ is pending.
That is a separate thing. We don't bother about it. So, as on date, your property stands cancelled, allotted to somebody else. And in that case, you must have made the cooperative society a party. And here, cooperative society is absent. Heard the learned counsel's opinion on behalf of the parties. During the course of hearing, it transpired that the cooperative society is not a party in the present proceedings. And as per paragraph 13 of the plaint, the deed of exchange was prepared and presented for registration in the office of District Sub-Registrar Bokaro Chas on 3/8/2015, duly signed by both the parties as well as countersigned by the Secretary of the Cooperative Society. But on that day, their deed could not be registered, and ultimately, the defendant had taken away the deed from the registry office unilaterally on on
31/8/15.
yes. On 31/8/2015. Upon this observation made by the court, the learned counsel for the parties seek adjournment to examine the case further. With the consent of the counsel for the parties, hold this case for further arguments on Monday. The counsel for the parties are also directed to prepare the short synopsis of arguments. मंडे को आपके सीनियर आ जाएंगे ना, उसमें खड़ा होकर टाइम ना मांगे, ठीक है? आप भी बनाइए, फाइल कर दीजिए.
From supplementary list, rating for final disposal, item 1, WPR 1347 of 2017.
Yes, yes.
The award is under challenge at page 68. The petitioner is the workman who was dismissed after an inquiry on charges of theft of company property.
Is the domestic inquiry was held to be fair and proper.
The domestic inquiry.
That order has attained finality.
That order has attained finality.
So what is there? Only quantum of punishment.
Apart from quantum of punishment, the award is also being challenged because it completely shuts out the evidence and the version of the workmen in the course of inquiry. Since there is no evidence on merits and 11A has been misinterpreted to mean only seeing the quantum of punishment.
That's not correct.
If I may place 11.
Yes, I am aware of it. That's not correct. We can also see whether the charge is otherwise proved on the basis of materials
so
on record.
that has not been done.
Natural justice, etc., will not be taken
Correct.
care of
So
because the procedural aspect is okay.
Yes, so 11A is wider than that.
That's
It is not confined to the quantum of punishment alone.
That's right.
Because the power has been conferred on the Labour Court to see the evidence to the extent of even granting the relief of reinstatement, which is expressly mentioned in 11A.
That's right.
In the award, the statements made by this workman and his defense taken in the inquiry has been completely wiped out, and only these statements recorded by the management have been believed to be true. So, shutting out the evidence of one of the parties in our submission leads to perversity. The second ground is a mixed ground, that there was premeditation in the inquiry itself, because the charge sheet was issued, and at the time of issuing the charge sheet, the management had already constituted the inquiry committee and had named the members of it.
That is not sufficient. That is too long drawn an argument. You have to demonstrate perversity in the inquiry report, right? And you have said that your defense has been completely not considered.
In the award.
Not in the award. Okay.
In the award also.
In the inquiry report, it has been considered?
In the inquiry, he was examined, and another co-worker was examined on his behalf, who later on retracted. Earlier, at the time when the charge sheet was issued, he gave a statement that he had met him on the date of the incident, that the worker was not carrying any bag with him or a bicycle, so therefore this charge that material was recovered from his cloth bag, which he had kept on the carrier of his bicycle, that was a false statement and it was
basically much on facts. You will not reappreciate the evidence under any circumstances. कुछ है नहीं आपके पास.
We are confining it only in the award that there is no discussion, there is no consideration at all. Maybe reappreciation is
Let
not
us see your written
permissible.
statement. Let me see your written statement.
Yes.
The written statement is at page 44.
Page
44.
I filed your type copy.
Type copy is there. Immediately after.
Read those paragraphs wherein you are questioning the findings of the inquiry report.
First paragraph.
These are all on procedural part. Show me that paragraph which deals with the findings of the inquiry.
On victimization, there was an allegation that he was being victimized.
Even that is
Para 22. And more specifically, his defense.
charge will show that victimized. This is absolutely vague. It has got. You see, you have to give certain details. Who is the person who is victimizing you? Most of the time, I find out in the written statement of workmen, there is no challenge to the inquiry report. They only challenge the procedure which had taken place in the inquiry. Most of the time, right? This is what has happened here also. So points which are not raised in your written statement, how the court will examine those aspects of the matter?
No, but the defense is there in the reply to the charge sheet. And since we strictly do not follow the law of pleadings
you
as
have to make
applicable,
you have to raise a point, no?
so the
There is
defense
no
is
such
there in
point.
the reply to the charge sheet. The
You see,
workman has
unless you raise a point that even on the basis of this, even on the basis of materials, this could not have been the inquiry report, how will the court examine it?
since the entire record of the inquiry is there and the reply is there, in the reply
Court
to
will
the
not
charge sheet.
things which you don't raise.
So
Court
in
will
the
not examine.
reply to
That will not make the award purpose. The points you have not raised in your written statement, you want them to basically appreciate all the materials and to be treated as an appellate authority. Something striking ought to have been shown by you in the written statement. Some plea should have been there. Nothing.
the reply to the charge sheet is that he has been victimized, he has been apprehended by a person with whom he had prior enmity, Karmakar. He names a person who was standing at the gate and who had apprehended him.
You made allegation against Karmakar. Was he examined?
Karmakar was
So, it was for you to take steps before the inquiry officer.
in the
When you are
award.
making allegation of victimization against a particular person, even if they do not examine, you have to examine. And those procedural aspects are gone.
On procedural aspects, of course, the document part, of course, we have not challenged that order. That order, in fact, the LPA was withdrawn.
I wonder how this LPA could be prescribed by LPA withdrawn.
The LPA was actually withdrawn, should not have been, because there were vital points in relation to inquiry, including the allegation of bias by the inquiry officers, which was a point on inquiry. But even otherwise on merits, because the award does not take into consideration the version of the workman at all, and since there was no recording
I
of
want
the
to
defense.
know which version of the workman as taken in your written statement has not been considered. You want
version as
just
in
a
the
moment.
inquiry. It
Just
was
a moment.
examined in the inquiry.
That's right. You want that irrespective of any plea having been taken in the written statement, the court is under an obligation to find out as to whether the inquiry leading to punishment is proper.
This is a case where the court is not recording any evidence. This is a case where we accept that the inquiry procedurally is fair, and therefore our case is that while examining the correctness of the findings in the inquiry, at least the statements made by the workman in the course of inquiry, he was examined in the inquiry, at least his version should have been examined, considered, it could have been disbelieved.
So the court
But
will
it has been shut out by the inquiry officer, and therefore the inquiry is purpose. As well as the court also does not take into account that there has to be discussion, at least an objective consideration. It cannot, the inquiry cannot become the mouthpiece of the management where it blindly accepts the material, the evidence, documents placed by the management representative. So we have only challenged it on that aspect that the inquiry is completely one-sided. And the award is also equally one-sided. It does not take into account that a probable defense was set up. It could have been disbelieved by the inquiry officer by recording proper reasons.
Where is the inquiry report?
Inquiry is part of the LC.
Which is that judgment which deals with the scope of 11? You were just citing one judgment.
This is the judgment, paragraph 23.
Right? Judgment. Give it to the other side also. Can you read it?
Paragraph 23. In this backdrop, when we see unusually long judgment of the learned single judge, it comes out that the learned single judge held firstly that the tribunal had exceeded its powers vested in it under the provisions of Section 11A of the Industrial Disputes Act. The learned judge, as regards Section 11A, after quoting the same, observed, though the tribunal was equipped with the power to come to its own conclusion whether in a given case the imposition of punishment of discharge or dismissal from the service is justified, it is for that purpose that the tribunal is authorized to go into the evidence that has been adduced before the inquiry officer in detail and find out whether the punishment of discharge or dismissal is commensurate with the nature of charges put against the delinquent. So far as the finding of the learned single judge appears to be correct. However, the whole thrust of the judgment has changed merely because the industrial tribunal has found the inquiry to be fair and proper. The learned judge seems to be of the opinion that if the inquiry is held to be fair and proper, then the industrial tribunal cannot go into the question of evidence or the quantum of punishment. We are afraid that this is not the correct law. Even if the inquiry is found to be fair, that would be only a finding certifying that all possible opportunities were given to the delinquent and the principles of natural justice and fair play were observed. That does not mean that the findings arrived at were essentially the correct findings. If the industrial tribunal comes to the conclusion that the findings could not be supported on the basis of the evidence given, or further comes to the conclusion that the punishment given is shockingly disproportionate, the industrial tribunal will still be justified in reappreciating the evidence and of the court, interfering with the quantum of punishment, there can be no dispute that power under section 11A has to be exercised judiciously, and the interference is possible only when the tribunal is not satisfied with the findings and further concludes that punishment imposed by the management is highly
We have
disproportionate.
seen the principles of law. Now you see the award. Everything is well discussed. Even the procedure of the evidences led in the inquiry has been discussed by the learned presiding officer. It is not a case that the presiding officer has confirmed the punishment merely because the inquiry was held to be fair. It is not. That is not the approach of the presiding officer. You just see. From the perusal of the proceeding, it appears that the stolen marked materials were produced in the inquiry, marked exhibit. These he has gone through the records of the inquiry officer. How do you say? There is nothing in your case. He has examined it.
So far as the management's case is concerned,
No,
but
we
on the
will not
next-
say. You see, whatever it is, he has considered whatever evidences were produced, those materials were marked exhibit. It is not a case that only because the inquiry was held to be fair and proper, the action of the management has been affirmed by the learned.
But only few lines of the same paragraph.
Yes.
Paragraph 31.
Yes.
Last about 4-5 lines. So far, the submissions made on behalf of the workman is concerned, it is well settled that when an inquiry has been held to be fair, even adequacy of evidence is untenable.
Certainly.
Interference is possible only when
Adequacy, you see, adequacy of material. It is not a case of no material. How much would be the quantity of material is that cannot be really examined. इतना तो आप करते हैं किस? You are well aware of the principles of law. Not a case for you. You can appreciate that somebody might be watching you, but there is nothing in this case. We really cannot interfere. Yes, Mr. Das.
And
allegation of theft is there, which the findings are to be reported on the basis of preponderance of probabilities. There is one case of 2018, where it was a case when in the criminal trial he was honorably acquitted. The Honorable Supreme Court said, Your Worship, that once.
It's not a case.
No, it was not on that.
Required.
Said that once the proceeding is.
You have to satisfy this court that the principles of law as laid down by the citation given by him has been followed. That is all.
That satisfaction
That
has
has
been
been followed.
Yes.
And in a case of theft, dismissal is certainly one of the accepted punishments.
And then the rate of the pleadings are to challenges on two law. One is propriety of the inquiry proceeding, which he cannot argue. Second is proportionality. Theft, when the allegation of theft is there, it has to dismissal is the proportional.
For the learned counsels appearing on behalf of the parties, this petition has been filed challenging the award dated 14/6/2016 passed by learned presiding officer Labour Court Jamshedpur in reference case number 1 of 2005 within bracket annexure 9, whereby the learned court has held that the dismissal of the petitioner by the respondent management is justified. The learned counsel for the petitioner has submitted that an order was passed by the learned presiding officer Labour Court that the domestic inquiry was fair and proper, that was challenged before this court in a writ petition being WPC number 2138 of 2012, and the writ court dismissed the writ petition by holding that the court rightly returned a finding that the domestic inquiry conducted against the petitioner was fair, proper, and in accordance with principles of natural justice. The order passed in the writ petition was challenged in LPA number 424 of 2014, which was admitted for final hearing by the order dated 5th of April 2016. And in the meantime, the learned Labour Court proceeded and passed the impugned award. However, during the course of arguments, it transpired that LPA number 424 of 2014 has been withdrawn while order dated, order announcement, while order dated 30/10/2018. And thereby the finding of the learned Labour Court that the inquiry was fair, proper and in accordance with the principles of natural justice has attained finality. To this, the learned counsel for the petitioner has submitted that merely because the inquiry was held to be fair and proper, the action of the management cannot be automatically upheld by the learned Labour Court. The necessary inquiry in terms of section 11 capital A was required to be conducted by the Labour Court, and the scope of inquiry under section 11A, even when the inquiry is held to be fair and proper, has been, for this purpose, the counsel for the appellant petitioner has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket close 12 SCC 726 para 23, which is quoted as under. The learned counsel has submitted that not only the proportionality of punishment is to be considered, but it has also, the Labour Court is also required to consider as to whether the findings of the inquiry was supported by evidence brought on record. Yeah. The learned counsel submits that the impugned award does not satisfy the requirement of necessary inquiry in terms of section 11A of the Industrial Disputes Act, and therefore the impugned order is perverse and calls for interference. The learned counsel for the respondent has opposed the prayer and has submitted that in the writ petition, primarily only 2 points have been taken by the petitioner. The first one is relating to the legality and validity of the domestic inquiry, of the fairness of domestic inquiry, and it has been asserted in the writ petition that the LPA was pending. And secondly, the punishment is shockingly disproportionate to the charges levelled against the workman. The learned counsel submits that the petitioner has been found guilty of theft of items of the respondent industry, and in case of theft, the punishment of dismissal cannot be said to be shockingly disproportionate. Rather, the punishment is adequate and proper. He has further submitted that the impugned award reveals that the industrial tribunal has not confirmed the action of the management merely on account of the fact that the domestic inquiry was held to be fair and proper. The tribunal has taken care of the materials placed on record and has found that the workman was found guilty of misconduct by the inquiry officer. He has in particular referred to the findings recorded by the learned Labour Code, which commences from paragraph 25 to 34. In response, the counsel for the petitioner has submitted that has referred to last few lines of paragraph 31, wherein the court has observed that when an inquiry has been held to be fair, even adequacy of evidence is untenable. And interference is possible only when it is based on no evidence or is wholly opposed to evidence on record. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and also the scope of inquiry under section 11 capital A of Industrial Disputes Act as observed by the Honorable Supreme Court in the judgment of Mavji C. Lakum Supra. This court finds that the learned Labour Court has not proceeded merely on the ground that the inquiry was held to be fair and proper. Rather, the learned Labour Court has considered the materials on record and has also referred to the various materials which were brought on record before the inquiry officer and has discussed not only the inquiry report but also the materials placed before the inquiry officer, including the plea of victimization of the petitioner within bracket paragraph 28 of the impugned award, and also the question, the authority of the officer to issue charge sheet, etc. within bracket paragraph 29. The legality and validity of the report and finding of the inquiry officer within bracket para 30. And has also recorded that there was enough oral and documentary evidence to establish the charge against the petitioner before the inquiry officer, who has found the petitioner guilty of the charges. The learned Labour Court has also recorded that the adequacy of evidence cannot be questioned, and the question of interference would come only when the findings are perverse, that is, based on no evidence or wholly opposed to evidence on record. The law is well settled that the Labour Court does not sit in appeal against the inquiry proceedings and also the inquiry report. The learned Labour Court has also considered the further submissions with regard to transfer of the workman and rejected such plea by observing that the workman had never pleaded anyway that his transfer was illegal, and the workman had also not adduced any evidence to show and to prove that his transfer was illegal, and he was forced to join HBXL Limited and has lodged any complaint in this respect before any competent authority. The learned court thereafter considered the proportionality of the punishment by paragraph 33 and held that, considering the seriousness of misconduct, the order of dismissal was rightly passed by the management. Just a moment. This court finds that the learned labour court has thoroughly considered the materials on record. It was placed before the inquiry officer and case of the respective parties, and is of the view that the labour court has acted in terms of the requirement of scrutiny under section 11 capital A of the Industrial Disputes Act, as has been laid down by the Honorable Supreme Court in the judgment which has been cited by the petitioner in the case of Mavji C. Lakhun Sutta. The judgment relied upon by the petitioner does not help the petitioner in any manner. हाँ बताइए.
In our opinion, this is a clear case where departmental inquiry was able to be fair and legal and proper. We also went through the record of the case where the departmental inquiry was properly held and was therefore legal and proper. So far as the quantum of punishment imposed on the respondent is concerned, having regard to the nature of charge,
The learned counsel for the state respondent has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2018 bracket 1 SCC 285 to submit that in a case of theft, the charges are very serious and the punishment of dismissal is fully justified. Para 29 and 30 of the aforesaid judgment is fully justified. उसमें ऊपर ही submission नहीं किया. Can't help it. वो आप जजमेंट नहीं लाए जिसमें इसको नहीं एग्जामिन कर सकते हैं. Quantum of evidence. There are judgments on that also.
Only perversity has to be seen, not the quantum.
तो आप कहाँ लेके आए? आप तो लेके नहीं आए कुछ. इनको बोलिएगा तो इनके पास ढेर जजमेंट होगा.
11A came by way of amendment. Before 11A, iron and steel 67 said nothing can be looked into.
Yes.
Then the amendment came in 7111A. Then Firestone case gave the entire.
Certainly not an appellate authority.
Yes.
Not an appellate.
So that is discussed in para 22 onwards of this judgment. Firestone has also been discussed.
हम काफी दिन लेबर बोर्ड में बैठे थे तो I have some idea about.
Firestone भी इसमें discuss.
ठीक है देखिए. SK चतुर्वेदी और क्या क्या. SK चतुर्वेदी was from service.
That is from service jurisprudence. Judicial review with respect to department.
Now under the new labor code, what are the changes? The forum changes or not?
The forum actually changes because now there is no labor code. There will be only an industrial tribunal. It will be a multi-member body with different benches for different kinds of matters.
It is just like a tribunal, generally functioning like a tribunal, and no appeal.
No appeal. There is no appeal.
Straight away.
Straight they did.
So the jurisdiction of the labor court is now wiped out.
In fact, it will become maybe a slightly wider, but since it has not yet been constituted, we are continuing. We don't know. There is so much shortage of judges with multi-member bodies. The functioning will become even more complicated. Because now dismissal matters have to be heard by a division bench of the labor court with at least a deciding judge and one member.
From the daily list, under heading for final disposal, item 11 WPL 1290 of 2005.
लास्ट डेट का एक बार ऑर्डर दे दिया जाए।
एडजर्नमेंट चाहिए आपको?
नहीं, इसमें मैडम ही नहीं है, रिक्वेस्ट उन्हीं का आया हुआ है कि उसमें कुछ रिलीजियस फंक्शन के लिए रांची से बाहर है। इसमें 27/1 का ऑर्डर हम लोग को टाइम ये बोला गया था कि वन टाइम लमसम कंपनसेशन पर एक कंस्ट्रक्शन मैनेजमेंट से ले लेंगे। वी हैव रिसीव्ड एन ईमेल फ्रॉम द ऑर्डर।
क्या वन टाइम लमसम में क्या है?
वन टाइम लमसम में
उनको भी दीजिए बेको।
इनको तो ऑलरेडी कदम भेज चुके हैं सब। तो 50,000 पर वर्कमैन देने का बात हुआ है। मैडम को मैंने कल कम्युनिकेट कर दिया था और मैडम का कहना था 28 वर्कमैन है तो 28 मल्टीप्लाइड बाय 50,000 ये हम लोग को आज हम लोग को दे देंगे। मैडम से मैंने कल इंस्ट्रक्शन लिया, मैडम का कहना है कि वी आर नॉट इंक्लाइंड टू सेट। ये हमको बोली है 31 तक हम नहीं, ये भी बोली है।
Yes, when do you want, madam? Tell me. Date? You can speak in any language you want. हाँ? नहीं कॉल करने की जरूरत नहीं है, उन्होंने आपको बोला होगा ना कि कब इस आपसे क्या बोल रही हूँ? नर्वस थी, इनके पास इंस्ट्रक्शन नहीं है कब का डेट नहीं पास होगा, क्यों करें हम? आप बताइए उन्होंने कब बोला? अगला डेट में हम टाइम नहीं देंगे। और उन्होंने बोला है ना 31 के बाद।
31 मार्च के बाद वो सेम हेडिंग में रहने के लिए
फाइनल डिस्पोजल।
हाँ, फाइनल डिस्पोजल।
Counsel for the petitioner is present. He has submitted that as per the competent authority, they are ready to offer a sum of rupees 50,000 per workman as one-time payment in lieu of regularization. There are 28 workmen involved in the present case. He has also submitted that he had a conversation with the counsel appearing on behalf of the respondent, and it appears that the respondents are not ready to accept this amount, and therefore the matter has to be argued on merit.
And one thing more, we have already filed our written notes of argument.
The written notes of argument on behalf of the management has already been filed. MS नाम बताइए। MS शिप्रा शालिनी, लिख के दीजिए अपना नाम। Advocate submits that the arguing counsel is out of station, but she has no instructions, no further instructions. It appears that the case is required to be heard on merit. Pose this case under the same heading on 8th of April. ठीक है? आपके अनुसार डेट नहीं है। कम से कम ये तो आ गया ना, उनको एक्सेप्टेबल नहीं, नहीं तो उस दिन फिर 1 महीना के लिए डेट हो जाता। तारीख पे तारीख का कहानी खत्म करते। चलिए, मैडम को खबर कर देंगे ना। काउंसिल फॉर द रेस्पोंडेंट undertakes to communicate this order to Mrs. M.M. Pal, senior advocate, the arguing counsel in this case, right?
Item 12 WPL 4657 of 2005.
You are for the
State.
for HSA.
Yes, Your Lordship. The
Yes.
name of Mr. Raju is
Yes, sir.
the lady is praying for next week. I've got the files today, so I'm just praying for next week.
You've got the files today.
Yes,
Mr. Rajiv Ranjan is there in this case since beginning. He was a standing counsel of HSA.
yes,
Yes, sir.
but I have got the file.
You will assist the court.
Yes,
Your file your wakalat nama.
not yet. I work with Mr. Raju.
Sorry.
I work with Mr. Raju.
Nobody appears on behalf of the petitioner. Counsel for the respondent is present. He seeks adjournment. And submits that the matter will be posted next week. Post on Monday.
Okay. Item 13, WPL 4810/2012.
आपको कल क्या परेशानी है?
कल छोड़ के उनको किसी
उसको फाइनल डिस्पोजल में डालेंगे. सुनिए, उसको फाइनल डिस्पोजल में डालेंगे. फाइनल डिस्पोजल में है वो?
Yes, final disposal.
ये भी फाइनल डिस्पोजल में
जी.
है. Counsel for the petitioner seeks adjournment with the consent of the parties and by way of last indulgence. The matter is directed to be posted on Monday.
Item 14, WPL 6035/2012.
तो यहाँ टाइम लेने के लिए खड़े हैं क्या आप लोग? क्या इंस्ट्रक्शन लेना है? कोई इंस्ट्रक्शन नहीं लेना. नहीं, हम ऐसा नहीं. हमारे यहाँ से ऐसा नहीं. आपको बहस करना करिए, नहीं तो हम डिसमिस कर देंगे. आप बताइए लास्ट ऑर्डर में क्या है? WPL 505. नहीं, WPL नंबर
6035.
कहाँ है? ऑर्डर लास्ट ऑर्डर.
Order number 15, order dated 21/1/2026.
ये जो 505 का है वही तो एजेंट की है ना, जिसमें आपको एक्सेप्टेबल नहीं है.
नहीं, ये दूसरा केस था 505. उसमें क्या हुआ था कि वन टाइम कॉम्पनसेशन जो हम लोग ने ऑफर किया था वो कंसर्न रेस्पोंडेंट ने एक्सेप्ट कर लिया. तो इसमें आगे करती थी, इसमें आज से ये आगे करें तो कल हमको बोले कि नाउ आई एम नो लॉन्गर एट काउंसिल इन दिस केस. तो आप कंपनी से भी अभी कुछ है नहीं.
क्या इंस्ट्रक्शन चाहिए आपको?
इसमें मुझे बस ये लेना था कि ये जो रेगुलराइजेशन का अवार्ड हुआ है उसको नहीं इम्प्लीमेंट करके क्या अगर वन टाइम कोई ल्यूक्रेटिव अमाउंट
मीडिएशन में भेज सकते हैं, वही चाहिए. यहाँ पे क्या हम लोग को यहाँ पंचायती थोड़ी करना। आप जाइए मीडिएशन में, सब लोग जाइए, ऑल ऑफ यू गो फॉर मीडिएशन। वी आर नॉट हियर टू एडजर्न केसेस क्या आप सेटल करेंगे नहीं करेंगे। go and get it settled through mediation. दो वर्कमैन है, आप चल जाइए मीडिएशन। जलसा भेज देते।
In the previous hearing, there was a joint request that if it can be settled.
That's right. That's right. There is a likelihood of settlement, isn't it?
In fact, it
I will
came
send
from
it
their
for
side,
mediation.
so I had to take
I
it.
can appreciate. किसी वो देंगे वो सारा मीडिएशन में होगा। With the consent, I am sending it for mediation. आप जाइए मीडिएशन में अपना कहानी खत्म करके सेटल करके आइए। यहाँ पे हम सेटलमेंट का पंचायती नहीं करेंगे। I'll not do this. We are here to adjudicate the cases on merits. आपको सेटल करना है, आप जाइए मीडिएशन में।
Mediation, if it can be said, because it will also probably put more pressure on the clients. They can sit together and decide finally. So
हाँ मीडिएशन में भेज देते हैं।
Either if they want to
yes
settle,
no
they
जो
can
होना
settle.
होगा ठीक है, नहीं तो we will decide the case on merits. क्योंकि ये ना एफिडेविट ये वो करने से कोई फायदा नहीं, ठीक है? आपको इंस्ट्रक्शन तो होगा, आप तो अपीयर हो चुके हैं, वकालतनामा फाइल कर दिए। WPL number 6035 of 2012. After hearing the learned counsel for the parties, it appears that there is a likelihood that the matter can be settled through mediation. With the consent of the parties, place this case for mediation through Jalsa. The parties shall appear before the Secretary Jalsa on बताइए डेट बताइए 15th April. On 15th April 2026 at 11 a.m. The Secretary Jalsa shall appoint an expert mediator who is well versed with labor disputes, है ना? The mediation report be submitted by 30th April. ठीक? Post on 5th of May. 5th May and supplementary for list. जो होगा पार्टीज जाएंगे अपने बैठ के डिसाइड करने में क्या करना है। दैट इज ऑलवेज बेटर। कोई बात नहीं, कोई ना कोई केस तो आपको बहस करना ही पड़ेगा। चलिए नेक्स्ट केस पर
आइटम 13 WPL 3134 of 2014।
आप बोल रहे थे ना लेबर मैटर के लिए डेट फिक्स कर दीजिए। जब डेट आता है खाली टाइम मांगते हैं। हाँ बताइए। Where is the petitioner? एक आध केस DMT कर लो, वही सही है। Nobody appears on behalf of the parties. No adjournment request has been circulated. Seeking adjournment. This petition is dismissed for non-execution.
Item 16 WPA 5599 of 2023.
Should have please to see order 18/11/2023.
18/11/20.
Yes, yes, ma'am.
Yes.
We have been directed to make, in case we should make amicable settlement in this relation. Several meetings took place, but unfortunately the settlement could not take place. Therefore requesting to listen to this matter on merits.
Yes, yes. I'm here to hear the case on merits.
We have started this.
You start.
This is the written notes which I have. Your Lordship, may I address the court to the imperial order at page 76? Workman has represented the case. Your Lordship, before starting this, may I read the quote about the fact that in the year 1986 to 87, several workmen were appointed on daily wages to do some labor work or some labor work in the irrigation division. In the year 1995-96, they have been terminated. The reason that due to the paucity in the fund and less work in the division, they have been terminated. After the lapse of 10 to 11 years, they have referred their case before the Labour Court, and the Labour Court has passed this order. The order is at page number 83. May I read this one?
Yes.
Accordingly, I find that their removal from service not legal.
Yes.
Page number 83.
Yes.
Last two lines, madam. Accordingly, I find that their removal from service not legal, and they are entitled for regularization in the service along with all wages due to them during period of litigation within 3 months of this order. On two law points, this case has been decided. First, whether this litigation division comes under the purview of the definition of industry as per section 2J of Industrial Dispute Act, and the second one, whether their termination was legal or illegal. What is the finding of the Labour Court? I want to draw attention to this court, which is at page number
79.
Yes.
May I read this one? The same word industry with same meaning is mentioned in section 25F of IT Act. According to the nature of work, construction of barrage, tunnel for flow of water and making arrangement for irrigation, it is clear that the unit is engaged in construction work and the work done in this unit falls in definition of industry. From perusal of the record, it appears that in preliminary inquiry, this fact is already considered and the court has already concluded that the department is an industry and the reference is good. On the basis of this, they have considered that the irrigation division is an industry and on the later state, the termination was illegal. This order was passed. My contention in this WPL is that it does not come under the purview of industry. Why? The reason is there are many judgments in this. The most relevant one is the Bangalore sewage board judgment, which was passed by 7 judges bench division, but it was come under the purview of reference by the Honorable Supreme Court in 9 judges bench division, which is this is the case status.
That's right. You see, that will change the law prospectively. No, whatever has happened, the main discussion there is that with the passage of time, this is required to be reviewed because now there is lot of changes in the society and the obligations of the state are much wider. That it does not say that it has been wrongly decided, and even if there is a reference, we are still bound by the judgment which has been decided till it is overruled. So we are not going to adjourn it on that ground.
Ma'am, but I
One thing more, they cannot come back to the pavilion once they agree.
There was a reference.
Yes.
A reference was there.
No, either agree. They conditional last but one judge.
जब आपसे पूछेंगे तब आप कोई जवाब नहीं देगा, आप बैठ जाइए, अभी इनको बोलने दीजिए. So that is not a ground for adjournment. I will not adjourn it on that ground. At Tom's, yes.
No, ma'am.
I am aware. अभी इतना तो बात चल रहा है उस पर. This Bangalore water supply.
But sovereign function, what is the main output of the irrigation region? It has a sovereign function to supply water to the public. It is doing its welfare function. It is the duty of them. It is not a.
With respect to the same department, there are numerous judgments of our court also.
I have got one judgment.
कौन सा judgment? Honorable Justice चंद्रशेखर साहब का एक judgment DV में.
There is a DV. That judgment I got.
और उसके बाद वाले judgments नहीं लेके आए हैं.
Of 2014, I have got a judgment of 2014 passed by the Supreme Court. Reference was made to say para 16 and 30.
अभी इस पर judgment की इसको consider करें. Yes, please. Para?
Para 16 to 13 now.
16 to 13?
16 to 13.
उल्टा चलेगा?
6 to 13 now. I apologize for this. May I read this one? My industry was not taken into consideration.
अच्छा, कौन-कौन सा judgment लेके आए? ये लेके आए और कौन सा लेके आए?
It has been obtained by the of judgment.
Sorry?
Single bench judge. This 2 judgment which I have given.
हमको ध्यान है हम 2-3 जजमेंट किए हैं.
सर्च करते हैं.
Honorable division bench has held that the minor irrigation division, in my case it is a major irrigation division, it has categorically stated that it is not under the purview of industry. That's why I am.
Who has to prove that they were performing sovereign function? Where is the order? You see, in the preliminary inquiry, this fact is already considered, and the court has already concluded that the department is an industry and reference is good. Where is that order? Because the entire crux of the matter is there in that order. Where is that order?
On that preliminary order.
Yes, where is that?
Even 1 week time, I will bring
1
this
week
on
time. अभी तो आप बोल रहे थे बहस करेंगे. अभी आपको 1 week time चाहिए.
But I also want to bring that preliminary.
I am absolutely clueless. There is a specific reference to an earlier order in the impugned award, and you are not concerned with that.
I don't need that. Maybe even 1 week time. I will
No,
bring
I
this
will not
on
give you anything.
I will bring that order.
No. Why should we give you time? हमारा 15-20 मिनट बर्बाद करके आपको टाइम चाहिए. तो ऑर्डर पड़े उसी समय आपके दिमाग में आना चाहिए कि इसके बिना कैसे डिसाइड होगा ये.
But the definition of it is I will bring the
यहाँ पे एक आईए क्यों फाइल की?
it was for the extension of
No, there is one आईए. कोई आईए पेंडिंग है यहाँ?
Yes, the IU is for the compliance of the
Which आईए?
IU number 3324/2026.
What was this आईए for?
for extension of file for the compliance of the SU and order for allocation and give us return. I'm wondering maybe given to me. I will go through the judgment which was passed by Mediation and permanent bench. I will go through this. Only just one chance be given to me. I will bring that preliminary objection as well. Just one chance be given to me.
The hearing of this case has commenced. Counsel for the petitioner submits that primarily 2 points are involved in the present case. Firstly, whether the petitioner is an industry within the meaning of Industrial Disputes Act, and whether the award of back wages, full back wages, is justified in the facts and circumstances of this case, particularly when the industrial dispute itself was raised after expiry of about 10 years
10 years.
from the date of removal of the concerned workman. It further transpired that from paragraph 6 of the impugned award, that one order was passed by which the order was earlier passed by which the court concluded that the department is an industry and the reference was good. However, the said order has not been placed on record. Counsel for the petitioner seeks adjournment. The counsel for the petitioner has further submitted that, has further relied upon the judgment passed by Honorable Division Bench in the case reported in 2014 SCC online JHAR 2907 within bracket Pranay Kumar Srivastava and others versus State of Jharkhand, and submits that in the said case the minor irrigation department was held to be not the state. The present case relates to major irrigation department. He then submits that the said judgment, he has referred to another judgment reported in 2005 SCC online JHAR 474 with the bracket State of Jharkhand versus Jwala Rao they've heard and has submitted that similar view has been taken by the learned single judge that minor irrigation department is not a state. That means that the same principles will apply in the present case also. Since the order by which the department was held to be industry and the reference was held to be good has not been placed on record, the counsel for the petitioner seeks adjournment. Tuesday, post on Tuesday in the supplementary cause list for further hearing. Tuesday, Wednesday. In the supplementary cause list, ये final disposal में है?
Yes.
For final disposal. By way of last intelligence.
May have been from one more submission. The stay may be extended till that.
कुछ नहीं आप बेसिक रीडिंग ही नहीं समझ आता है.
This was sealed, and that
अब
was.
सर अभी आप उस दिन दस बजे.
No, उसी order there is an order. So far the execution proceeding is concerned, they have filed petition.
The proceeding has commenced, no? अब कुछ नहीं होने वाला. अभी वेडनेसडे को बोली मंडे को रख देते. करेंगे मंडे को. Will you do it on Monday? Objection.
Objection the order.
Yes. आपको मिलेगा तब ना वेडनेसडे तक मिल जाएगा आपको.
The executive engineer is also sitting and
Call.
ask him to.
Ask him.
Let me call him. Execution case में chief executive engineer office को seeking this stay.
कब सीखते?
सील 18/11 के ऑर्डर से 2 दिन लगेगा. इसलिए वो ऑफिस अगर वो बंद हो जाएगा ना तो बाकी पब्लिक रेफरल जो भी फंक्शन होगा वो सारे यहाँ पर हो जाएंगे. नेक्स्ट डेट तक के लिए अगर उसमें अगर स्टे दे दिया जाए तो नेक्स्ट डेट में तो
स्टे किया जब सीवी हो गया तब क्या स्टे?
जब हुआ था तो फिर ऑफिस को ओपन कर दिया गया.
ऑर्डर से ओपन किया था.
In view of the order of the executing court, the order, the office was sealed.
Now there is an interim order passed in this case.
On 18/11/2020.
The interim order passed earlier is continued till Wednesday.
Till Wednesday.
इससे हो जाएगा आपका काम. इससे हो जाएगा आपका काम. पूछिए इससे हो जाएगा.
Item 17 WPL 873 of 2016.
In this case also there was a direction regarding this one-time settlement.
आपको क्या इंस्ट्रक्शन?
I received an email that some more time is required to make an offer from the management. The award is in favor of the management.
There is a likelihood of settlement.
They have asked for some more time. I have received an email only yesterday saying that
They are still exploring it.
They are still exploring
They
what
said the
amount
mediation.
can be offered.
Exploring है तो भेज सकते हैं मीडिएशन में. मीडिएशन में भेज सकते हैं मैडम. जालसा में जाके मीडिएशन कराइए. ठीक है. देखिए भेज दें. मीडिएशन में जालसा में भेज सकते हैं. वहाँ जितना पैसा लेन देन होगा वो हो जाएगा डिसाइड. इंस्ट्रक्शन लेके आइए. कल रखते हैं. ठीक है. In view of order dated 28th of January 2026, it appears that there is a likelihood of settlement out of court. The counsel for the parties, the matter is adjourned for tomorrow, so that the parties may seek instructions if the matter can be referred for mediation. Post tomorrow.
Item 18 WPL 7502 of 2017.
And the payment of national liability. And this matter, the quantum involved, the amount involved is quite minimal. Only the law point has to be seen for calculation of gratuity beyond 30 years of service, whether 26 days every month has to be considered or 30 days.
Beyond?
Beyond 30 years.
Considering the small amount involved in this case, do you think that this issue should be decided in this case?
Yes, because this would have further repercussions as well.
We'll keep the question of law open. We'll keep the question open. But considering the small amount, if it can be paid, it's okay. You see, there is a reason for it. Whenever any small amount is involved in very important point of law, the matter would not go higher. So ultimately, if we pass a judgment, it becomes binding on everybody. So in an appropriate case where this is a contested issue, you should have contest in those matters. छोटा trivial amount के लिए इस तरह के issues को decide करवाना सही है.
39,227.
Who is the petitioner?
I am for the basis.
I will keep. Can you seek instructions to this effect? We'll keep the question open. And considering the quantum, or we can send it for mediation. Mediation में भी हो जाएगा कि payment कर देंगे, issue पर decide होगा नहीं.
4 is not appearing, that's why I am disappointed as an amicus.
Oh, respond number 4 is not appearing.
So he has been appointed as the amicus. So mediation.
The issue was in the appellate order, also the issue with what has been raised in the red petition in Lordship, that has been decided on the Bombay High Court bench, Western Goldfield Limited versus Babulal Akhtari. That was decided that has been submitted to the judgment.
That has been cited in the judgment.
In the appellate order judgment, that the better terms of gratuity, that all the employees entitled for a better terms of gratuity and a service beyond 30 years can be considered after 30 years of service, 30 days full wages shall be calculated. That is the only thing. And in this issue, Your Lordship, that she has superannuated after the passing of NCWA 9, Your Lordship. She was given gratuity as per NCWA 8. NCWA 9, after enactment of NCWA 9, she was entitled as per that. As per 1,000 wages, wages was earlier calculated as 810 per day. And now she has filed before the controlling authority as per 1,000. That was decided earlier by the controlling authority. 1,58,9,000 was to be paid. Thereafter, a corrigendum was issued. Then it was reduced to 1,19,000. Then again that corrigendum was withdrawn, and then again it was made to 1,59,000. The appellate authority has given a detailed finding with regard to all these issues after taking into consideration the judgment of the Honorable Bombay High Court.
Where is the judgment?
The judgment, appellate order judgment is.
No, where is the judgment of Bombay?
I have not got it. Instruction was given that whether an appeal was preferred against that judgment was not.
There is a direct judgment of Honorable Supreme Court that was a single bench judgment. Para 4 and 5 may kindly be seen, wherein it is, though it is an older judgment. Para 4 and 5 would be relevant. And that has perhaps this issue has been decided by your lordship.
Against me in a case in which I was appearing for the workmen, whether 26 or 30 days the same.
WPL
282 or
WPL number 282 of
2018.
2018. निकालिए तो इसका प्रिंट और ये भी चेक करिए ये अपील में गया है कि नहीं, अपील में गया है
We have filed LPS
पेंडिंग।
And this judgment is direct on that point only, which I have
इसको
to
कंसीडर करके ही किए होंगे, ऐसे बिना कंसीडर किए तो नहीं।
because सर्च करने पे यही एक जजमेंट आया है जिसमें स्पेसिफिकली 26 डेज को कंसीडर करने के लिए बोला गया है एंड नॉट 30 डेज।
Any stay in that? No stay. हम तो अपना कवर करके कर देंगे, आप अपना LPA में जाके उनसे ज्वाइन करेंगे। See, you should also be heard in the LPA, ना? वहाँ LPA से कुछ हो जाएगा तो फिर
It is gone in favor of JCC.
It has gone in favor 26 days.
आप देख लेंगे। We have decided it. Then if the workman wants, you can go. He is not interested. Maybe he is alive or not. We do not
That
know
was
that.
before publication was done, she didn't appear.
During the course of hearing, it transpired that the judgment passed in WPL number 282 of 2018 may have some bearing in this case. The learned counsels undertake to examine this judgment. 467. Immediately after bail matters, first case. Right? Taken up immediately after bail matters as first case.
From the list, real में 77 सुबह mention किए थे.
हाँ yes, वहाँ कहाँ है?
My lord, I am the counsel for the other side.
Respondent.
Respondent. Yeah.
Okay.
My lord, I am the petitioner.
Okay.
I am the respondent. So I am the party. So if some date may be fixed, because this is way down. I am not fully prepared.
When do you want to argue? You will argue or somebody else will argue?
I am.
When can you get ready?
Second.
2nd April.
My lord, actually he wanted first one very important matter.
Okay, 2nd April.
Second.
The matter has been mentioned for being taken up out of turn with the consent of the learned counsel for the parties, post this case for final disposal on 2nd April. The parties to file their short synopsis of arguments along with the judgments which they seek to rely upon. Latest by 1st of April. ये आप हमारे कोर्ट मास्टर को दे देंगे, हमको बताकर, ठीक है? 2nd April को।